Very good morning. Acting Eastern Cape High Court Judge Tembeka Ngcukaitobi set aside Loyiso Coko's 7-year sentence, saying that the findings of the Makhanda Regional Court were erroneous. The court had found Coko guilty of raping his girlfriend, a Rhodes University master's student, on the 1st of July in 2018. The overturning of the conviction has sparked outrage among gender activists who argue that kissing someone does not bind you to having sexual intercourse with them, and that is a decision that is dangerous in light of the serious issue of rape as well as GBV in South Africa. Now, joining us to discuss this conversation is the head of the Gender at the Center of Applied Legal Studies and attorney at Law Sheena Swemmer. Sheena, a very good morning to you. Thank you so much for your time. What do you make of this judgment?
Well, I think the judgment is problematic, and it's problematic when we look at the degree and the scourge of gender-based violence in our country. The consideration of the judges and what they considered as evidence as to why the accused thought he had received consent is really steeped in rape stereotypes around what consent is, and doesn't really accord with anything in our law at this time.
I mean, this judgment obviously speaks to GBV that's currently happening in, there's a pandemic essentially in South Africa at the moment. What do you think this has done in that fight for justice for women's rights?
I mean, a colleague of mine had said very sadly that this has taken us back 300 years. I mean, it has taken us back, and that's the sad thing, is we are constantly battling just to keep a status quo in the judiciary and in our law of being progressive around rape laws, although the country is in a state of what President Ramaphosa has said, the second pandemic, which is GBV. So we're constantly having to fight regression in law whilst having the second pandemic onslaught against us.
Now, this, let's just unpack this case a little bit more, and especially the judgment from Ngcukaitobi. The woman was interested in other forms of sexual intercourse, but she didn't express the desire to have penetrative intercourse at all. Mind you, she was also a virgin. I mean, it does seem a little problematic, and you said that it is a problematic judgment, but in terms of Ngcukaitobi, how do you think he should have handled this whole case?
Well, I mean, we do have to remember that it wasn't only him. So he's an acting judge, and there was a judge sitting with him. So I think both of them I'm not saying to blame, but both of them had a misdirection of law here. But I definitely think the issue around we say complainant, constantly reasserting that she didn't want penetrative sex is incredibly important around the fact that she didn't want to engage in a certain type of sexual activity. I think what the court correctly did find is the fact that she was a virgin is because in the magistrate's court, there was a lot of talk about the deflowering, and therefore consent was even more of an issue. I don't think it matters if you're a virgin or not. Consent is consent. So even people who aren't virgins have an interest in not being raped. So I think the High Court was correct in its view around the magistrate court misdirecting or looking at the virginity aspect, but I think they were misdirected in the consideration of kissing or other sexual activities perhaps being construed as consent. And I think that's where they definitely had a misapplication of law.
I mean, again, it's that big C word, consent, that you're talking about. Unpack the differences between expressed consent and implied consent. I think that is where the lines were blurred as well.
And I mean, you're entirely correct, and this is where there has been a lot of conversation recently in the last few days, where people have said that the Sexual Offences Act perhaps isn't clear enough on express consent versus tacit consent, and perhaps we do need to revisit that, and it does need to be made clearer in our Act. I think at this point it is clear, but these are conversations that are being had. But for the most part, you would consider both tacit consent and express consent. When we look at things like tacit consent, someone perhaps pushing you away, someone closing their legs. That's what it actually said in the judgment. She had closed her legs. Those would be seen as tacit, but there was also very explicit instances of expressed non-consent, where she had said, I do not want to have penetrative sex. And I think she had both of those elements. But perhaps the legislature does need to revisit the Sexual Offences Act and make this extremely clear as to what our law requires for consent.
I mean, she had consented to have the oral sex or sexual intercourse, but not all the way through. It is something that now seems to also be blurred lines within the judicial system as well, where the consent seems to be overarching. It seems like it's given at the start, and it essentially cannot be withdrawn up until the deed has been performed.
So that is one of the takes that many people have had on that. The real question that the judges were looking at there was, did this individual, the accused, believe that he had consent? And I think that's where the problem comes, is if you grow up in a society where you're conditioned to rape stereotypes, that if you, as one saying says, a kiss is not a contract, but some people think a kiss is a contract to have sex. So I think that the real thing here was, the accused, did he believe he had consent to penetrate her? And that's what the judgment actually turned on. And I think if we have a problematic society where people think buying a woman a drink means you can have sex, then it's not actually surprising that this is replicated in our case law.
I mean, this is something that happens, and I'm sure there are plenty of women who have had similar incidences and maybe not have come out and spoken about this. But how do you approach this as a consenting woman, as a consenting man, maybe consenting to have a kiss and maybe go a little bit further but not all the way? How would you suggest, to be in line with the law, would this have to be approached?
I mean, I don't want to suggest that women have to almost sit down with a man and make him sign a contract and say to him, this is all we're going to do tonight, because it's almost insulting to the rationality of men. I think there needs to be conversations in our homes, in our schools, in our families, that when somebody doesn't want something, they don't have to scream it from the rooftops. You can see it in many other ways in our normal everyday interactions. If someone doesn't want to eat food, they might push their plate away. But we don't say, oh, you paid for that food, you better eat it. I mean, we see lots of ways people tacitly show that they don't want to do something. But when it comes to sex and sexual encounters, all of a sudden people forget the things that they see every day that are tacit. So I definitely don't condone a way where women have to be explicitly saying that they don't want to have sex. I don't want to have sex. I think we need to have discussions about both tacit and express consent. I
mean, and perhaps that could happen outside of that environment, not necessarily when the moment is hot and heated.
Exactly.
Now, in the judgment, Ngcukaitobi went on and said it was evident, the evidence of the appellant Coko, that throughout the encounter the complainant was equally active participant. She was not merely passive. Does that matter in this instance?
I would say it's a problematic reading, because you can be an active participant in the forms of sexual activities that you wish to take part in. So if you wish to kiss someone, you can be an active participant. If you wish to have oral sex, you can be an active participant. But when it steps into the realm of something you didn't want to do, it doesn't matter that you were an active participant in the previous encounters or the previous types of sexual activity. It doesn't work on a kind of continuum that if you are saying yes to the first thing, which may be kissing, you're saying yes to everything. And it's something that emerges in rape law quite a bit, but it doesn't emerge in other instances of our life where we just assume if people say yes to one thing, they're saying yes to everything. So it is, again, a really problematic view that both society has, and it's entrenched in our judiciary and in our prosecution and in our various legal entities in the country.
Absolutely. Thank you so much for your time. Sheena Swemmer, she's the head of gender at the Center for Applied Legal Studies and an attorney at law. Sheena Swemmer, just unpacking that very controversial case, sparked a lot of debate from both sides of the coin.